with my phone too, so I can see better. Can you let me in there with?
Can you actually make out the names as they're typed on their little windows?
Yeah, if I've got my phone up here, and that's what I'm doing from now on.
Oh, okay. All right, I'm gonna let everybody in.
Okay.
Okay, as soon as I have an audio connection with everyone, we'll get rolling. Looks like I do. So Shannon, put us on the record, please.
Go ahead, Judge.
Okay, this is the matter of tapping versus Slack. Counsel, could you state your appearances, please?
Yes, Your Honor. My name is Gary Bankson. My P number is 57250, and I represent the plaintiffs, Chris and Lindsay Tapping.
Good afternoon, Your Honor. Richard Lindsay here on behalf of Eddie T. Slack and Kathy M. Slack, Slack Michigan LLC, and Thomas Polder and Carrie Poulter.
All right, and Shannon, do you have all those spellings?
I sure do.
Okay, so this is plaintiff's motion. Counsel, I have read all of your submissions, but you can go ahead with anything else you think I need to know in order to make a ruling.
All right, thank you, Judge. I do have a quick question. If Your Honor, if you received our reply brief to the response, and if you've had an opportunity to peruse that.
I did.
Okay, great. All right, great. Well, given that obviously the court has indicated that the materials have been reviewed, I don't have much to add. I guess what I would like to do is particularly draw the court's attention to Exhibit K of our plaintiff's brief for summary disposition and this is the exhibit, a letter that was written and provided to the plaintiffs by Erin Snyder. She's an examiner with absolute title in Ann Arbor. I used to work in absolute title myself, Judge, back in 2004. Even then, she was a senior examiner with a lot of experience. And I think her exhibit speaks well to the situation in this unrecorded subdivision, which is basically everyone is driving over private roads to access their property. And yeah, there has to be a lot of forbearance, I think. I mean, even the defendants are driving over private roads, not roads they own, but roads owned, that are in the names of other people, or easements over their land to access their own road or their own property. And if it were the case that individual owners within the subdivision decided to start making claims that these easements no longer exist, et cetera, we would have a pretty big problem on our hands. So I think Exhibit K is a very important part of our exhibit, or of our argument. Beyond this, however, the reason I've brought our motion for summary disposition, Judge, and I recognize that it might be considered early in the process before close of discovery, but the case that I cited, Morris versus Caridian, which I detailed in our brief and support, I believe compels a result at a minimum on the issue of blocking access to my client's property anywhere along Pebble Drive, whether that's up at the top of that drive, at the bottom, whether it's 10 feet, where it's 20 feet. The Court of Appeals was unequivocal. There cannot be any blockage of any portion of a piece of property that abuts an easement or road that's used, by adjoining landowners or nearly adjacent landowners. So I believe Morris Caridian and in fact, the Court of Appeals said it was wrong for the trial judge to even not grant a motion for summary under the circumstances. I don't see how, I mean, in my many years as an attorney, I rarely found a case that was as on point or as valuable to a case I was litigating as this one. And if the court feels the same, I think the result must obtain along the lines of how the Court of Appeals ruled in that case.
Let me ask you about that case. Was there a claim made in that case that whatever easement rights were granted by the dedication in the plat were extinguished by the doctrine of adverse possession?
I don't believe that was involved in that particular case, Judge.
But isn't that what's involved here? Isn't that the approach that the defendants are taking? Is that whatever rights the various lot owners in this unplatted subdivision may have received as a result of the original conveyances by the original plator, that those have somehow been extinguished by the doctrine of adverse possession?
That is, I would certainly say that.
Mr. Lindsay,
I'm sorry, Judge.
is that the argument you're advancing?
You're correct, Your Honor.
Okay.
Your Honor, if I might just briefly reply on that, the doctrine of adverse possession would go to title. It wouldn't go to extinguishment of the easement interest. And I believe.
Wait a minute. My understanding is the argument that's being advanced is that, in fact, the right, the easement right itself was extinguished by adverse possession. I mean, irrespective of what the state of the underlying title is, which I think you indicated it really doesn't matter.
That's correct, Judge. I didn't see any case law, in the defendant's brief and response arguing. I'm willing to look at any case law that might have been cited, but I didn't see any that would suggest that the doctrine of adverse possession would be utilized here to extinguish an easement interest. I did happen to take a gander at Cameron's on this issue, and it's extraordinarily difficult to use, to extinguish an easement using the doctrine of adverse possession, much more difficult than it is to extinguish title. If there's a case, I'd be interested to see it. I don't think it was pled.
Okay. Well, that was, I guess, the disconnect I had between your assertion that that Court of Appeals case is dispositive if it doesn't even address what I thought was the primary argument being advanced by the defendants.
Well, I think, Judge, the defendants are arguing that the easement is extinguished or gone through disuse. That seems to be and it seems to be how all our exhibits are framed. No one's using it. Obviously my clients beg to differ on that front. And I know that could be a factual issue, but I did not see an argument to the effect that the easement is extinguished by adverse possession. I didn't see any case law in support of that.
Well, I'll let you.
I guess.
Whatever other arguments you have, I'd like to hear from Mr. Lindsay on that specific issue.
Sure.
Your Honor, I guess initially, and I think this is conceded to some extent, but title resides with the Slacks or with Slack, Michigan. There were quitclaim deeds that were given about 30 years ago relative to that. So as I see it, the issue of material fact, first of all, I don't think that case is applicable because it was a recorded platted subdivision and dealing with abandonment of a an easement within that type of a subdivision, which this is not. The other issue is just going back to that affidavit in 1980, and then a number of affidavits which we submitted, and that's precisely the issue, that there is a limit, not abandonment, but that it's only been used for my clients and for the one other property that is to the east of lot 31 for that period of time. Now, I didn't find, again, I'm reading the same Cameron books that the court reads and the plaintiff's counsel reads. I don't see any definitive case law dealing with this. Clearly, we can establish it. And in my mind, clearly it's a factual issue, which precludes summary disposition right now. But I think that's clearly before the court. And we filed a counterclaim. Go ahead.
I don't see how non-use in and of itself would ever extinguish an easement of record. And there's numerous record references to this disputed walkway or alleyway or whatever it is, driveway. I think it would require a whole lot more than non-use. I think it would require exclusion. So to use the most current example, had your client's predecessors in interest built a fence blocking access to that use of that strip. Well, I guess we're talking about two strips now. Let's just use the walkway across the front as an example for what I'm posing. I think actually excluding from the use certainly could give rise to an adverse possession claim. You've got a clear act denying the owner of rights to this easement with use of that easement. And if they sit on their rights for 15 years, it's too late. They can't sue to do anything about it. But I didn't see anything to suggest any action of your clients and, more importantly, their predecessors in interest of denying access to other lot owners. And wouldn't you need that in order to get adverse possession of an easement?
I think the affidavits covered that it's been used only for those particular lot owners. So it may be in the language that was the thought with the language in the affidavits. So just as an example, my clients, both sets of clients, with this particular issue have said repeatedly, you can't trespass. This is our property. We've taken those actions. I think there will be testimony to support that going back way farther than 15 years from these parties and from others that they have been excluded. Now, I think the court may raise the issue of, was there ever a fence put across that? And there was not a fence put across it. It wasn't feasible to do that based on it being used as a driveway. So I guess to the extent that's what's required as far as exclusion, and I'm not sure that's the case under Michigan law, but there's not been a fence or anything like that.
Well, it's got to be open, hostile, adverse, etc. And for an easement that's clearly being used by more than just your immediate clients, to tell the rest of the world, or I guess in this case, the rest of the owners of the subdivision, put them on notice of the hostile. It seems to me you'd have an awfully high standard to show that they were excluded. And I think you have to show that they're excluded if you're going to get adverse possession of an easement. I mean,
Judge, if I might very briefly, just to address very quickly the issue of exclusion, lot 34, which is also to the right as you turn right going down Pebble Drive and onto Shorewalk, lot 34 is owned by the Clinks. They are not parties in title or parties to this litigation. If the idea is that it's open, exclusive, notorious, hostile use. That would, I would suggest, I mean, I'm not the attorney for the Clinks, but I would suggest they would find that rather alarming, that in fact they are driving down there solely at the discretion of the people who own the lots surrounding their property. Their access to their property is solely at their discretion and not the use of an easement to access their own land at lot 34. As to exclusion, I just don't see, I mean, as a plain matter of fact, as a kind of genuine issue of material fact matter, the Clinks are using it. And I don't think the defendants could deny that. And what then the question becomes, what are they using? And I think undoubtedly they are using the same easements that all the lot owners and my clients have access to.
Okay, so Mr. Lindsay's telling me he believes they can possibly unearth some facts that would show that specifically your client's predecessors in interest have been denied use of, and I lost the name of the road.
Pebble Drive.
Pebble Drive. Thank you. I frankly am skeptical that there's ever going to be enough evidence to convince this court that the elements of adverse possession as to the easement is going to be satisfied. But I'm perfectly willing to give every opportunity for, I'm told discovery has not ended yet. But if that's where I land, I can tell you where I'm headed. Absent proof that the easement was itself extinguished by adverse possession, I'm going to find that the plaintiffs absolutely have the right to use that driveway. Now, the scope of the use, I mean, we may quibble about that, and I realize there's issues about drainage, et cetera. But in terms of access to Pebble Drive, I think, Mr. Lindsay, you have got a very, very uphill battle to convince me that that has been extinguished by adverse possession. And I think that's what you have to show.
Judge,
Understood, Your Honor.
If the court is going to proceed then on the idea of maybe a further factual development of the issue, if the court is inclined to do that, I would like to ask, in the meantime, my clients are stuck. They are unable to effectively access the lake as things stand. There is a fence, there's a ditch, there are rocks, and there are trees, blocking not only my client's access, but also the access of the other neighbors to Shorewalk who might be using Shorewalk, at least some of whom my clients have pictures using. So I would ask the court if we can get some sort of temporary, if that is where the court is going, if we can get some sort of temporary injunctive relief so that my client can put his dock in, so my client can use, I mean, my client has built, I mean, a big house. He's laid out a lot of money, you know, not just for this case, obviously, but, you know, all around, my client has got a lake house, and he's put it by a lake because, you know, and he wants to enjoy the use of that lake. That he is forestalled from doing by those things blocking his access on Pebble Drive.
So let me, yeah, go ahead, Mr. Lindsay.
Okay, can I understand, Your Honor, I would just vigorously oppose any kind of injunctive relief. Obviously, that's not in front of the court. They haven't haven't pled that, haven't established any basis for any kind of preliminary relief. And I guess I want to say that I understand what the court's saying relative to the adverse possession, and I understand what we have to prove. But beyond that, there's a whole issue of what the scope of the easement would be if it still existed. I don't think there's any evidence that it's for these plaintiffs to access the lake from that driveway. They have access, as I indicated in the documents that are attached, they have access from the south end of their lot. They can walk and do everything along their lot. There's no expectation they had of using that to access the lake. And frankly, it was their contractors and their guests parking on this driveway that raised these issues and kind of brought this to a head. There's no right for them to park there. There's no right for them to have their invitees park there. And frankly, Your Honor, I would hope that nothing would be entered without the court and the parties taking a look at exactly what this looks like. I mean, the court is very experienced, I'm sure, with these lake cases that are very tight quarters. And really, they're just expanding their use out beyond the edge of their property to be able to push on to my client's property. I mean, if they were to use that driveway, I guess, to go down and access one of the other houses along the front of the lake, that would be one thing. But I mean, they're talking about a greatly expanded use from that. Again, if the court visits, you can see this easily.
I would say at a minimum, they have the right to use that. If I find it wasn't extinguished, they would have the right to use it to access the front of their property. I don't see how in the world you could limit access to their property anywhere along the edge of that Pebble Drive and their boundary. As to what use is made of the end of it, where there's supposed to be a park or whatever, I realize that issue would be subject to the development of a lot more than what's in the record right now. But if they've got a right to use that easement, they certainly have a right to use it to access their property anywhere along that easement.
Well, Judge, if I might, just briefly, Judge, if I might, the defendant's own chain of title references a driveway. It doesn't even say walk. It says a driveway. I mean, they use their cars to park down there, and I know they're going to say, oh, well, we own it. We should be allowed to do so. But it is referenced as a driveway. And, I understand the court, it's a scope question, but all my client is asking to do is to be able to use, we're willing to work with the defendants to reach amicable results. It's been hostile in one direction since my clients moved in. And I understand why. I understand the defendants, they've got a VRBO going. They want to sort of create a nice idyllic area. My clients came in, took an undeveloped piece of land, built a big house on it, and that's interfering with the plan. But my clients are willing to work with. My clients are not trying to prevent the Slacks, the Poulters, anyone from accessing their property. Only the defendants seek to prevent my clients from accessing their own property. And so that's why, I think what's good for the goose is good for the gander here, Judge. And that's why, at a minimum, I would ask, given spring coming up, given summer coming up, that they should be given the ability to access their land in this way.
When does discovery close?
May 4th, is it, Judge, I believe? I could be wrong.
I'm working from home. We had a positive exposure in my courtroom. So I do not have the court file. All I have are your briefs and exhibits on the issue that's in front of the court right now. So I don't have the entire file. I don't have the scheduling order.
May 14th, Judge.
The other question, I couldn't really tell. I know there were statements in your brief about the steep terrain. Are you telling me it's impossible for your clients to access the lakeshore portion of their property except over this easement?
Well, Judge, two things. One, obviously, I don't want to make an argument that we're trying to establish an easement by necessity, because I don't think it's that. But I will say
No,
this. Yeah.
I'm not asking you anything of the sort.
Okay. But what I will say is, and I talked with my client earlier just about this question in particular. So they have a side-by-side they can drive down, and they use that to drive down Pebble Drive and put in dock sections and to ferry a disabled relative down there. And they use a roadbed for that purpose on Pebble Drive. My client's own property is steep and does not have a roadbed on it. There's no drive on it. And the concern is, and it's a good concern, is that driving that vehicle with kids on it, with a disabled relative on it, or with heavy equipment on it, it's gonna overturn on slippery grass and that sort of thing. They also have a 6-inch curb they've gotta go over. At a minimum, it's dangerous for them to use their side-by-side on their property to access their lakefront.
Well, they can walk. They can walk over their land from their home down to the lakefront, can they not?
They can walk, but they can't get dock. They can't get a dock down there. They can't take a disabled relative down there, Judge. Not safely.
Your Honor,
Okay,
it's my understanding that they've already installed their dock. So this whole idea they can't do certain things, first of all, is a factual issue. And second, I just think it's premature for the court to rule on that.
Well, that's where I was headed. If they were going to be, I didn't know how much longer before you're able to fully exhaust whatever's available factually about adverse possession as to the easement interest itself. But I didn't want to be denied the boating season because they couldn't get their dock in the water. If they've got their dock in the water, that's there's less urgency. I guess what I would say, Mr. Bankston, that if what you're asking the court to do is issue a preliminary injunction, you should file a motion seeking a preliminary injunction. I'm not prepared to make a dispositive ruling about this case for the reasons I've already indicated. However, I don't have to make a dispositive ruling. I only have to evaluate likelihood of success. So if you wish for the court to consider some sort of preliminary injunctive relief, you need to file a proper motion seeking that, and I will certainly hear it and consider it. And maybe by the time you're able to get that done, we've had a resolution. Well, part of what I wanted to do today was to communicate where I'm at in terms of where I'm likely to land on this. And again, if the defendants are unable to provide me with what I believe is going to have to be very convincing evidence of exclusion, there's a doctrine within the whole adverse possession legal framework that there has to be some act of disseason where the owner is disseized from the property, and there's something significant that puts the owner on notice of this disseason. And I believe in this case, it's going to be a very, very hard task to show that the plaintiffs or their predecessors in title were actually disseized of the easement right. It's a whole lot easier with respect to the fee interest. It's a much harder thing with an easement, and the fact that they didn't use it doesn't convince me of anything. Everybody knows this was unimproved land. It was a wild piece of land, and there probably wasn't much use of it, but failure to use it doesn't exclude it. It'll never disappear for failure to use. It can disappear if they're actually excluded from using it and fail to take action within the time frame that the law allows for doing that. So I say that because I think you folks ought to go to the some facilitation or some mechanism to see if you can't work all this out. But I'm likely to end up at a place that says the plaintiffs indeed still have an easement right over this property, over this Pebble Drive.
Your Honor, you stated exactly where I was going to head. Now that you've given some indication of where you stand on the case, which is always very helpful. Would you be willing, if we can stipulate to an order, to push the dates out a little bit to allow us to do facilitated mediation? I mean, it feels like we would be negotiating the scope of the easement use based on what you're talking about. And, you know, with that, with the guidance from the court, maybe that's something we can do.
I don't mind doing that, but I don't want to foreclose Mr. Bankston from seeking a preliminary injunction if that's what he wants to do. And I think the two could go forward side by side. In terms of issuing a dispositive ruling, I don't want to have him be prejudiced, but I also I don't want to see his clients wrongly deprived of the full use of their property any longer than absolutely necessary.
Personally, Judge, I would like to keep the discovery dates where they are, only because, you know, if the issue is really a factual question as to whether there was exclusion, as the court indicates, then I would rather sooner that issue be addressed than later. If that factual issue cannot be developed to the satisfaction of the court, then I want to get my clients relief. I mean, if the court is inclined to grant it. If, you know, as to a motion for preliminary injunction, certainly I'll file one and set it on for hearing. I believe it was actually the motion itself was not motioned up. But I did request injunctive relief at least in our complaint. So that's there. But with respect to other issues, I'm not opposed to the notion of trying to work things out, if that's especially as to drainage issues in particular, because there's no such thing as halfway blocked. That's the problem I have. You know, you can't be, all right, you know, we'll take the rocks out, but leave the fence. You can't have a halfway solution on that issue. It's either they can block it or they can't. We need it. We need, you know, a closure on that. But with respect to drainage, I understand there can be some factual issues to develop there, and maybe that would be more subject to facilitation and providing everyone's willing to do that.
Well, and that's, facilitation is always a good idea. I think it's always better if parties can get together and work out something that they can all have as their solution. When you come to court, there's winners and losers, and that doesn't necessarily make for better neighbors. I would hope that at some point, it's not much fun being at odds with a neighbor, especially at a lake where you're trying to relax. And and I understand how everybody got to where they are. I get that. But hopefully, by what I've communicated here today, you can see at least at some level, I'm likely to grant the use of Pebble Drive. Knowing that, why not sit down and try to work it out? So I'm not going to order any extension of discovery, but I would strongly encourage that you talk to a facilitator sooner rather than later. Invest your efforts in reaching a resolution.
Judge, does the court maintain a list of facilitators?
I'm not allowed to recommend a facilitator without going to the court list, and we have to go down it in order. You're far better off if you can find someone that you both can agree on.
Okay.
If you ask me, I've got to go to the list, and I will tell you, there's probably a very small number of people actually on that list that I would strongly recommend that you go to. So
Okay.
I wish I could tell you more. They specifically addressed it in the rule. Apparently they don't want judges referring people to facilitators who are their friends.
Understood.
We've got somebody here in town that we've used quite a bit, and the judge would be familiar with. So I'll get you a couple of names suggested.
Right.
Your Honor, one other question before, if in fact he does file a motion for preliminary injunction, we would really like the opportunity to have you take a look at the property to see how it lies. Is that something the court would be willing to do?
Sure. I love a good field trip.
Let's get a day above 75 and see if we can get out there. Okay. Well, so would the process be for us to come up with some days and suggest them to you, or how best to do that? Or just work with your office?
Just tell me where it is and I'll give heads up to somebody and I'll just walk out and look at it. I don't want to talk to anybody else while I'm there. I've got enough of a picture of what it looks like and I know what I would want to look at.
Okay.
Obviously, I'd have to give heads up so you don't shoot at the press that's trotting around in your front yard.
Good point, Your Honor. What I will do is one of us will get you an email and explain to you how to get there and what the issue, and then I'll copy the other side. So make sure you've got the information and then let our clients know as well.
And then when I know that I'll have a chance to get out there, I'll just shoot you both an email that says, hey, I'm going to be out there the afternoon of whatever, walking around.
Okay.
Tell you what the car I'm driving so they know when they see it coming down. They don't have to be alarmed. They can tie up their pit bull so he doesn't come out and chew my leg.
So we won't exclude you, Your Honor. We'll exclude everybody else.
Okay.
All right. Sounds good. Thank you, Your Honor.
You're welcome.
Thank you, Judge.
Have a good day, everyone.
Thank you.
Take care.